Sometimes the biggest revolutions start in the quietest places. In 1970, a book review, just a book review, kicked off this incredible clash of ideas. It was between two brilliant minds, and it completely reshaped how we think about the law. I'm talking about things that affect you every day, like your car insurance or the safety features built into your phone. And it all started with one simple question.
Right? Think about it. A car crash, an accident at work. Who's on the hook? Who has to pay for the damages? This very basic question is, believe it or not, the engine driving our entire story today. For literally centuries, the law had a pretty straightforward answer. But then, a totally new way of thinking came along and changed everything.
So before the 1970s, if you were a legal scholar, your world looked very, very different. To understand accident law, you wouldn't be looking at spreadsheets or economic data. Nope, you'd be in a library, probably surrounded by dusty books, because the whole field was really built on a foundation of legal texts and pure, logical reasoning.
And you can see the difference right here. You've got these two completely different worlds. On one side, the traditional way, which a young Richard Posner described as basically interpreting old texts. You'd read cases, look for logical consistency. It was all about what the words meant. But on the other side, something new was bubbling up. An approach that used social sciences, especially economics, to ask a totally different kind of question. Not just, what does the law say, but how does the law actually work in the real world? The person who really lit the fuse on this whole revolution was a Yale law professor named Guido Calabresi. His book from 1970, The Costs of Accidents, was an absolute bombshell. It grabbed that simple question, who should pay, and flipped it on its head, answering it not with old legal arguments, but with the cold, hard logic of economics.
Okay, so Calabresi's big idea was to break down the problem into pieces. He said that any accident, really, creates three different kinds of costs. First, you've got the primary costs. These are the obvious ones. Medical bills, a wrecked car, you get the idea. Then there are secondary costs. These are the ripple effects, like what happens when a victim can't work and can't pay their bills. And finally, you have the tertiary costs, which is just the cost of the whole system we use to deal with accidents. Paying for courts, judges, lawyers, all of it.
And this leads us to the absolute core of his argument. Calabresi said, look, the goal of the law shouldn't be to eliminate all accidents. That's just impossible, and it would be way too expensive. Just think about banning every car on the road. No, the real goal is to optimize the costs. The best legal system, he argued, is the one that minimizes the total sum of all three of those costs together. That's how you get the most efficient result for everybody. So armed with this powerful new economic framework, Calabresi turned his attention to the legal system that was in place at the time, what we called the fault system. It's the one we're all pretty familiar with, where courts try to figure out who was negligent, who was at fault. And let's just say, Calabresi did not hold back.
He straight up called it absurd and ineffective. Wow. So why such strong words? Well, because when he applied his economic lens to the fault system, he didn't see a well-oiled machine. He saw a system that was, in his view, failing on every single one of his cost metrics.
Let's break down his attack here. First, he said the fault system actually makes those secondary costs worse because victims might have to wait years for compensation. Second, it jacks up the tertiary costs with these incredibly slow and expensive court battles. Third, he argued that this whole moral idea of fault just gets in the way of making smart, economically efficient decisions. And finally, and this is a huge one, the system only asks who is at fault between, say, the driver and the pedestrian. It doesn't ask the bigger question. Could the car manufacturer have prevented the accident in the first place with a cheap safety feature?
So Calabresi's book lands with a huge splash. And one of the very first major reviews comes from this sharp young professor at the University of Chicago named Richard Posner. And what Posner had to say is what really adds the crucial twist to our whole story.
Now, first things first. Posner gave credit where credit was due. He saw the absolute genius in what Calabresi was doing. He called the book a powerful forensic and analytical machine. He praised how it just swept away all the old, kind of fuzzy ways of thinking about this area of law. He knew this was the future.
But after all that praise, Posner drops his big critique. It was a single but devastating point that challenged the very foundation of Calabresi's entire argument.
And there it is. Posner's knockout punch was just this simple phrase. Calabresi, he said, had a weak sense of fact. What he meant was that Calabresi had built this beautiful, powerful, elegant theory, but it was all just theory. It was based on assumptions, not on hard empirical evidence.
Calabresi claimed the fault system was absurd, but according to Posner, he hadn't actually proven it with data from the real world.
And right there, out of this intellectual duel, Calabresi's brilliant theory on one side and Posner's razor-sharp critique on the other, a whole new vision for the law was born. The point wasn't to pick a winner. It was to fuse these two powerful ideas together.
Posner's review was basically a call to arms for legal scholars everywhere. He was saying, hey, a good theory is great, but it's not enough. It's just a starting point. If you really want to know if a legal system is working, you've got to get out of the library and test your ideas against the messy, complicated facts of the real world.
And Posner didn't just criticize. He offered a path forward. He laid out a roadmap. He suggested, why not compare accident rates in places with different laws, like the insurance system in Saskatchewan versus other places? Or let's study history to see if the law changes when new technology comes along. In other words, let's stop just arguing and start turning these big theories into things we can actually test.
So this whole debate leaves us with this huge question. Should our laws be built on elegant theories or on messy, real-world facts? But this isn't just some academic squabble. The fusion of these two ideas, economic theory tested with real-world data, is now the engine behind countless rules that shape your life. It's why regulators do cost-benefit analyses on new pollution rules. It's why your insurance rates are based on massive pools of data. This duel of ideas from 1970 made it impossible for us to make laws based on logic alone. It forced us, and still forces us, to always ask the most important question. Okay, but what does the evidence actually say?